Of punishments. 4. Punishments. The punishments to which offenders are liable under the provisions of this Sanhita are a. Death. b. Imprisonment for life. c. Imprisonment, which is of two descriptions, namely 1. Rigorous, that is, with hard labor. 2. Simple. d. Forfeiture of property. a. Fine. f. Community service. 5. Commutation of sentence. The appropriate government may, without the consent of the offender, commute any punishment under this Sanhita to any other punishment in accordance with Section 474 of the Bharatiya Nagrik Suraksha Sanhita, 2023. Explanation. For the purposes of this section, the expression, appropriate government, means a. In cases where the sentence is a sentence of death or is for an offense against any law relating to a matter to which the executive power of the Union extends, the central government, and b. In cases where the sentence, whether of death or not, is for an offense against any law relating to a matter to which the executive power of the state extends, the government of the state within which the offender is sentenced. 6. Fractions of terms of punishment. In calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years unless otherwise provided. 7. Sentence may be, in certain cases of imprisonment, wholly or partly rigorous or simple. In every case in which an offender is punishable with imprisonment which may be of either description, it shall be competent to the court which sentences such offender to direct in the sentence that such imprisonment shall be wholly rigorous, or that such imprisonment shall be wholly simple, or that any part of such imprisonment shall be rigorous and the rest simple. 8. Amount of fine, liability in default of payment of fine, etc. 1. Where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited, but shall not be excessive. 2. In every case of an offense, a. punishable with imprisonment as well as fine, in which the offender is sentenced to a fine, whether with or without imprisonment. b. Punishable with imprisonment or fine, or with fine only, in which the offender is sentenced to a fine, it shall be competent to the court which sentences such offender to direct by the sentence that, in default of payment of the fine, the offender shall suffer imprisonment for a certain term, in which imprisonment shall be in excess of any other imprisonment to which he may. 3. The term for which the court directs the offender to be imprisoned in default of payment of a fine shall not exceed 1/4 of the term of imprisonment which is the maximum fixed for the offense, if the offense be punishable with imprisonment as well as fine. 4. The imprisonment which the court imposes in default of payment of a fine or in default of community service may be of any description to which the offender might have been sentenced for the offense. 5. If the offense is punishable with fine or community service, the imprisonment which the court imposes in default of payment of the fine or in default of community service shall be simple, and the term for which the court directs the offender to be imprisoned, in default of payment of fine or in default of community service, shall not exceed a. 2 months when the amount of the fine does not exceed 5,000 rupees. B. 4 months when the amount of the fine does not exceed 10,000 rupees, and C. 1 year in any other case. 6. A. The imprisonment which is imposed in default of payment of a fine shall terminate whenever that fine is either paid or levied by process of law. B. If, before the expiration of the term of imprisonment fixed in default of payment, such a proportion of the fine be paid or levied that the term of imprisonment suffered in default of payment is not less than proportional to the part of the fine still unpaid, the imprisonment shall terminate. Illustration. A is sentenced to a fine of 1,000 rupees and to 4 months imprisonment in default of payment. Here, if 750 rupees of the fine be paid or levied before the expiration of 1 month of pay imprisonment, A will be discharged as soon as the first month has expired. If 750 rupees be paid or levied at the time of the expiration of the first month, or at any later time while it continues in imprisonment, A will be immediately discharged. If 500 rupees of the fine be paid or levied before the expiration of 2 months of the imprisonment, A will be discharged as soon as the 2 months are completed. If 500 rupees be paid or levied at the time of the expiration of those 2 months, or at any later time while it continues in imprisonment, A will be immediately discharged. 7. The fine, or any part thereof which remains unpaid, may be levied at any time within 6 years after the passing of the sentence, and if, under pay sentence, the offender be liable to imprisonment for a longer period than 6 years, then at any time previous to the expiration of that period, and the death of the offender does not discharge from the liability any property which would, after his death, be legally liable for his debts. 9. Limit of punishment of offense made up of several offences. 1. Where anything which is an offense is made up of parts, any of which parts is itself an offense, the offender shall not be punished with the punishment of more than one of such his offences, unless it be so expressly provided. 2. Where anything is an offense falling within 2 or more separate definitions of any law in force for the time being by which offences are defined or punished. Or B. Several acts, of which one or more than one would by itself or themselves constitute an offense, constitute, when combined, a different offense. A offender shall not be punished with a more severe punishment than the court which tries him could award for any one of such offences. Illustrations. A gives Z 50 strokes with a stick. Here A may have committed the offense of voluntarily causing hurt to Z by the whole beating, and also by each of A blows which make up the whole beating. If he were liable to punishment for every blow, he might be imprisoned for 50 years, one for each blow. But he is liable only to one punishment for the whole beating. B. But, if, while A is beating Z, Y interferes, and intentionally strikes Y, here, as the blow given to Y is no part of the act whereby A voluntarily causes hurt to Z, A is liable to one punishment for voluntarily causing hurt to Z, and to another for the blow given to Y. 10. Punishment of person guilty of one of several offences. Judgment stating that it is doubtful of which, in all cases in which judgment is given, that a person is guilty of one of several offences specified in the judgment, but that it is doubtful of which of these offences he is guilty, the offender shall be punished for the offence for which the lowest punishment is provided if the same punishment is not provided for all. 11. Solitary confinement. Whenever any person is convicted of an offence for which under this Sanhita the court has power to sentence him to rigorous imprisonment, the court may, by its sentence, order that the offender shall be kept in solitary confinement for any portion or portions of the imprisonment to which he is sentenced, not exceeding 3 months in the whole, according to the following scale, namely, a time not exceeding 1 month if the term of imprisonment shall not exceed 6 months. B. A time not exceeding 2 months if the term of imprisonment shall exceed 6 months and shall not exceed 1 year. C. A time not exceeding 3 months if the term of imprisonment shall exceed 1 year. 12. Limit of solitary confinement. In executing a sentence of solitary confinement, such confinement shall in no case exceed 14 days at a time, with intervals between the periods of solitary confinement of not less duration than such periods, and when the imprisonment awarded shall exceed 3 months, the solitary confinement shall not exceed 7 days in any 1 month of the whole imprisonment awarded, with intervals between the periods of solitary confinement of not less duration than such periods. 13. Enhanced punishment for certain offences after previous conviction. Whoever, having been convicted by a court in India, of an offence punishable under Chapter 10 or Chapter 17 of this Sanhita with imprisonment of either description for a term of 3 years or upwards, shall be guilty of any offence punishable under either of those chapters with like imprisonment for the like term, shall be subject for every such subsequent offence to imprisonment for life, or to imprisonment of either description for a term which may extend to 10 years.